to be starting in just a minute.
Welcome everybody to tonight's planning board meeting of June 2nd, 2021. It's 6:30. Angela, if you would take roll call, please.
David Christensen.
Yes, here.
Deborah Burrows. Here. Edward Zelmanow.
I'm here.
Lori Anthony.
Here.
Diane Gray.
Here.
Absent are Devin Chamberlain and Michael Provencher.
With that, we have a quorum, and I will open up tonight's planning board meeting. The first thing on the agenda are minutes of the previous meeting, which have not been completed. So we are going to pass on those and go to new business and public hearings. If I recall, it's a public hearing for the Ivory Hills subdivision, and that application had been tabled in the previous meeting. So in order to bring that back, I will need a motion to bring it forward to the table so we may open the public hearing.
I'll bring that motion to bring it forward.
Thank you, David. And may I have a second?
A second.
Diane seconded. The Ivory Hills subdivision is now back on the table. And with that being said, I guess I'm opening the public hearing. Would you like to give a brief overview, or can we forgo that, and does the public just want to speak on this?
You can certainly allow the public to speak first if you choose to do that. That's fine.
Is there anybody here to speak on the Ivory Hills subdivision?
I would like to say something.
Oh, Amy, okay. Amy, and could you introduce yourself?
My name is Amy Beth Lucarelli, daughter of Richard Grant. I sent over the information to the planning board that there is a boundary issue, clearly marked not only just as an error in the tax map, but also in the deeds. We are currently pursuing the option of, we're having a survey done, and we are also working with a property attorney and Old Port Title to look into this, because lot number 3, as proposed, is actually, if you look on even your tax maps, has been paid in taxes by my great-grandparents, my father, and had been deeded over to both of them, and it pretty much this new survey and this subdivision wipes that right off the map.
Thank you.
So that's my concern, is that lot number 3, now narrowing that down to just mentioning the right-of-way to the Tibbetts family cemetery. It's more than a 10-foot encroachment on boundary. It really is a good chunk of property. And if the town pursues approving the subdivision, you know, I do have a concern there, you know, down the road. Not only have my family been paying taxes since the 40s on this property, but it does not match your records either. I guess that's what I have.
Thank you, Amy. Could you go to the podium and introduce yourself, please?
Scary. My name is Karen Hart. I'm an abutter to the project, to the subdivision project. I've been a Waterboro resident for 30 plus years, so this is first time attending. My question would be, what is the impact of this subdivision to the Cook Brook? Would it impact the flow, the quality, the quantity of water to homes that are below the project? I have a few other questions. Would you like me to ask each one now or wait?
Are you prepared to address these questions?
If she's talking about that being the brook, it's probably not barely even running at this particular point, but that's what you want to call a brook.
We'll
to-
go one at a time so
One
that
at
you
a
can
time.
respond.
Right, so I guess what I would say to that, I mean, you're looking at, there's one home site already here, you're looking at 2 more home sites, single-family dwellings, You're looking at, with Lot 3 specifically, it's a large, more than ample enough size lot for zoning code, so I don't know. I don't see the impact there personally. As far as addressing the issue that was just brought up prior to, we've had 2 surveyors look at this property. We've had a title search on this property. If this was in dispute for all this many years, you would have thought somebody would have come forward a lot sooner than this. We had the title search, there's title insurance. A lot of professional people have put their stamp of approval on this and put their professional opinion on the line. Whatever dispute or whichever boundary, we don't show it in our deed. Obviously, we've had 2 professional Maine State surveyors look at this, and they both agree that what they've put forth here is what we own. Does the tax map differ from what we have here? Yeah, it does, but that's not necessarily our issue. That is the town, they do the town maps. We don't do the town maps.
Town maps aren't.
And as far as, any dispute from years and years ago, I guess where I would put that is if this was an issue, why hasn't this been brought up before this? If this is going back, I don't know how many years, I mean, we're showing we all own the title to the property, or the Libbys do, and we've got the title search and the title insurance to back that up, so.
Thank you. How many questions? You had some more questions, right? How many do you have, please?
4.
Why don't you just stay, please? You don't have to
Just
jump.
rattle them all off. You can address them all at once.
I would like to know what type of houses are planned in the subdivision. Are they conventional or not modular or mobile homes? Can the subdivision be subdivided again, or is it as proposed with the 3 lots, I think, that we were looking at here? And would there be any blasting that might have to take place on a lot, just as a concerned person with my property below? And I guess my last question would be, does this subdivision change any future requests that I may have with land? Because I own a house on property and then the land behind it, which is close to being the abutting to the project. So would the approval of this subdivision impact any future plans that I may have for the land, for the lot that I have? Because I'm not an expert to know, boundary lines and that type of thing. So thank you very much.
Thank you.
I'll try to address these one at a time the best I can. Right. We're going to have a restriction there of no mobile homes. So maybe modulars, but modulars, no double wides, no mobiles. It's going to be in the deed. As far as a modular home, some of the manufactured modulars now are, they're just built in a factory there. It's not like they used to be. So I would suspect, though, in both these cases, on lot 3 and lot number 1, that you're going to be looking at a stick-built home. Are they going to be elaborate? I can't answer that. I mean, we're not going to restrict it to it's per size. I mean, if somebody wants to build a 20 by 40 ranch, that's really what they're going to build. As far as the blasting's concerned, you may see it. I can't say yes, I can't say no. It all depends on the house placement and what someone wants to do there. They've got their setbacks here that the town's established, and we've got the house sites drawn on here. They could move a little bit, but if I was to make any guess, if you saw any blasting, it would be on lot 3. Lot number 1 does have a taper that goes off where somebody could do a daylight basement there without probably doing blasting. However, they did blast on this other lot here.
Other lot, two, Steve?
This one is not part of the subdivision.
Lot 2.
No,
no.
right down next to the easement.
Oh, okay, all right, thank you.
And we're not building the homes.
Yeah, we're not.
We're not building the homes, we're just selling the land. Can it be subdivided again?
No, well, it could if somebody wanted to go through subdivision on this, but this land isn't layable for any further. That's my own opinion. Somebody wants to jump into that project, they can have at it. I don't see that happen. You get back here, you're building long driveways and stuff to do this, and then you're dealing with the wetlands issues there. They want to take it back to the town of Waterboro and go through this process for one lot. The financial gain or whatever for that is let me put it this way, we'd probably be doing it if it was probably financially feasible, right? It's just, I don't see that happening.
And then our final question is whether or not this subdivision would impact her for the
I don't know where she lives, if she lives down, you live down this way or this way? Up the hill or down below the CMP?
Well, I'm on Sokokis Trail.
Oh, so you're over here. You're over. I don't know where her boundaries come in here, but I guess since this land back here, I don't see anything ever happening to it. How it would affect what you decide to do back here, it really has nothing to do with this property. I mean, that would be up to you to make those decisions. And probably you'd have to start with a surveyor or some sort of a land management person to go out there and take a quick look at it for you. That's where it really has to start normally, is you start with your base plate of what do we have, and then you mold it then you work with what you have legally and what, a surveyor may have come up with, so.
PJ?
Yes.
I would say, as far as her last question, the wells are out front, the septic's out front. Any development on the rear is totally unimpacted by this property.
Any development on the rear of these lots or on the rear where her property is located?
She's asking if this subdivision is going to impact what she would like to do with her land, and I don't see it.
No.
We can't know.
I mean, her land is a completely separate situation.
And it's irrelevant.
And we wouldn't know what the impacts would be to her land or by her land until some sort of a development proposal came forward, if it was one allowed on her property. Relevant to this property, the state law, for example, requires a separation of 100 feet between septic system and wells, and it's clear that they're much greater than 100 feet away from any septic system, so impact to wells would not, I can't say would not occur. I don't know what the hydrogeology of the area looks like, but there's certainly a great deal of separation, hundreds and hundreds of feet between their septic system locations and that of anything that would occur on our property.
Thank you for verifying that, Lee J. Are you done with your questions?
Thank you.
Thank you very much.
Amy has a question.
Amy, once David unmutes you.
Hi, I guess I just wanted to address when it was mentioned why we hadn't pursued this previously. That was because we didn't know that there was going to be this kind of an issue. Previously, John Smith, the landowner, had done a survey that was never filed at York County Courthouse. The survey was never filed, nobody ever saw it, and there was the agreement of, hey, this land has only traded hands 3 times in 100 years. It really wasn't a question until we got the notification. As soon as we got the notification in the mail, that's when we started taking action, contacting code enforcement, contacting to see about having a survey. I reached out to the surveyor. I reached out to Mr. Wilkinson, as well as trying to find, after talking to them, and it being suggested that this wasn't going to go anywhere, to contact the property attorney. We have done our due diligence since we received this notification. Did we have it done prior? No, we didn't know there was a subdivision going in. We didn't know that there was, you've been paying taxes and you have the deeds and you're sitting there saying this is the property, and it's never really been a question. I've walked that property, my father's walked that property, I've met John Smith, the abutting landowners knew. It wasn't a question. So I just wanted to clarify that. This isn't coming out of the blue and saying, hey, this is literally, we did not know that there was this big of an issue until we were notified with the certified mail.
Can I ask a question? Lori,
Thank you, Amy.
can I ask her a question?
Sure.
I'm just a little confused, because you just did, I just want to make sure I'm right. Lot 3 is what we're discussing, Amy and John?
That's what she's brought up.
Okay.
Right.
Is Amy saying that they own the entire lot?
I don't know. I mean, I
No,
guess.
but a big part of it, I guess.
A big part, all right, because I didn't understand where she was referencing a graveyard. Is it up to, or the cemetery somewhere?
It's not on this property, I can tell you.
Okay.
I can answer that question if that helps. There is in the deed from Dearly Lumber to my great-grandparents and my great-grandparents to my father, a note at the end of the deed that says it reserves a right-of-way as well to the Tibbetts family cemetery, which is located out back.
Okay.
The cemetery is not on the property in question.
Okay.
The right-of-way that comes with this land was noted because it needed to stay accessible for people who need to come and go from that cemetery, so that it would always be deeded over as an access point. As it's surveyed now, the only thing that we have is that right-of-way.
Thank you, Amy.
A 10-foot area, that was what I was told by Mr. Everett, the surveyor.
I believe it's 20 and it's owned.
Madam Chair, I think we need to move off of this issue. If we have attorneys involved in this and it's becoming a legal matter, that it's not something that we should be delving into.
Yeah, and
I agree.
thank you. Is there anything else with the Ivory Hill subdivision? David?
I'll hold this question until we're finished with the public hearing. Thank you.
Well, thank you. That's appropriate. Anybody from the public, do you have anything else, concerns or questions on the Ivy Hill subdivision? Lee J., did you want to add anything?
Before really get into it, if there's someone else going to speak, I would close the public hearing.
Close the hearing now.
That's what I was hoping for. If no one else is speaking on the Ivory Hill subdivision, the public hearing is closed at 6:48 p.m. Thank you for coming and your concerns. Okay. Amy, thank you. I now open it up to questions, concerns, and comments of the planning board, and David, you look to be first.
My question is primarily to Lee J. We know that there's a conflict in surveys from registered licensed surveyor. We know that the presentation, aside from that conflict, seems to meet the standards of the subdivision. My question is, if this were to be approved by the planning board, what are the consequences to an adverse outcome to the petitioner who comes in and asks us to approve the subdivision?
Great question. So Ed started to touch on that in his statement that he had made. We have a stamped survey, stamped and signed survey by a professional surveyor in front of you. That is the only information you have that you would go on for this project. Any property dispute, such as there is, as Amy mentioned, is a civil matter between the two landowners. If it goes to court after you have approved the subdivision and they would rule in Amy's favor or Amy's family's favor in any way, and the court makes a decision, whatever the court makes for decision stands. So if the court says, for example, you need to give, Amy's family, you need to deed back, I don't know, 150 feet of whatever that frontage is, that is a court-ordered decision. And we would not get involved in that, and that would still be a lot of record, so we would just have non-conforming frontage. The only one that can make that kind of decision would be the courts.
Go ahead, David.
So, Lee J., if I understand correctly, the court would come in and review the presentations of both sides, come to a conclusion that may reduce the size of Lot 3 by a substantial amount, by a minimal amount, by some amount, or by no amount. That would not, if it made that lot non-conforming with our zoning rules, then would the developer still be able to develop it?
Yes, as long as it was court ordered. If the developer said, well, all right, I'll negotiate a settlement and I'll give you folks some of that, then he pretty much is going to lose that as a developable lot. But if the courts make that decision, and the judge rules on that, then that stands. That trumps everything.
So, again, so what we would be left with is then approving a lot on some speculation as to the outcome of the legal matter, and being bound, for better or for worse, as I recall those terms, to the court's decision, regardless of its conformance to our zoning or subdivision rules.
That is true.
Okay.
However, the only thing I would say to that is at this time, this applicant has come forward with a stamped signed survey, and what they have provided us is what we believe to be the truth. I don't doubt that there may be a property issue. That's a civil matter between the two abutters, but the information that has been provided by a professional surveyor with his name on it is the information we have to know.
So, can we condition an approval on a non-adverse outcome?
No.
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 Now,
No.
Okay, well, that's what I'm asking.
yeah.
So we have to do all or nothing back
I got one thing to
from our
say.
perspective. Thank you.
Correct.
Ed's next.
Yeah, Lee J., once the court case is finished and they've made the decision on the property boundary, the court's not reviewing this, but if it is an adverse decision to the applicant can come back to the planning board with an amendment to this plan. Can he not?
If the courts favor the applicant,
No, it doesn't. If the court comes back and moves the boundaries,
it shrinks the boundary.
it changes it in any fashion that
If the courts change it, then that's what trumps everything. The courts overrule anything that the planning board does.
But the court's not reviewing our decision, though. They're just reviewing a boundary dispute.
That's correct. But it is part of a project that has been in front of this board, and as long as that's the case, the courts trump anything this board does for an approval.
Right, so wouldn't the applicant have to come back with an amendment to this plan showing the boundaries as ordered?
No. No, it would just have to, it would have to be reflected on the town's tax maps, but it would not be reflected on the plan.
I think that's where the problems come in here. That tax map does not meet this map. It doesn't, they're not the same.
The town tax maps aren't the same name.
They're
No.
not boundary surveys.
So.
Tax maps are not
I
surveys.
guess this is all a hypothetical, right?
David, again?
So I dealt with I want to say another situation where the courts ruled because it was a divorce, it was a nasty divorce, and the courts ruled on the land was owned by the soon-to-be ex-husband, and the courts gave 2 lots to the, or 2 pieces of the land to the soon-to-be ex-wife, and she was able to split that and sell those without a subdivision occurring because the courts ordered that she get 2 lots. And she did not have to come before any boards in order to seek approvals because the courts already said, this is what you get. And this would be the same kind of a situation. They would not have to come back before us. Any deed corrections or anything to that extent would need to be done, but this board would not have any activity in relation to any lot line adjustments.
Thank you, Lee J. David's next.
So if those lot line adjustments have impacted environmental concerns or safety concerns, access concerns, we have no say.
Court trumps everything.
Okay, my second question is how long does it typically take for a matter like this to reach a resolution?
Years.
It could take months, it could take years.
Yeah.
I can tell you this, the courts right now backlogged about 47,000 cases right now. And so this civil matter would be pushed to the bottom. So this would probably take years.
Whose risk does this ultimately become?
The developers.
Okay.
I mean,
It becomes
not to sound callous, I mean, at this point right now, Amy and her family don't have any skin in the game in the sense that they have nothing to lose. The developer has potentially something to lose. And Amy's family has something to gain if the courts were to rule in her favor.
All set, David?
I'm thinking.
Okay.
Sorry, I'm an old guy. I get to take some time to think.
That's all right.
I'm not laughing at you, David, I'm laughing with you.
Yeah, I know. I'm laughing at me too. So don't feel too concerned. Okay. So essentially, if I break it down as I understand it, an approval by the board for this plan that ultimately gets subject to some kind of challenge in the courts is ultimately the risk of the developer, not the planning board, other than a potential deviation from our expectations on subdivision development if a court ruling came that was adverse to that. The other 2 lots that are part of this are unaffected by this.
Correct. Now, I will say,
Can we specify that in our approval in terms of some kind of acknowledgement that there is a dispute?
No,
And
no.
the other 2 lots are not subject to such a dispute.
so not in your approval, but what I was about to say was that type of a statement, Angela hopefully has that, or this meeting being recorded in some fashion, that could find its way into the findings of fact, but not as a condition of approval and not as part of the approval of the project, but just a statement in the findings acknowledging that this issue is occurring and could change things in the future. Basically, what you just said, David, would be some excellent wording that could be found in the findings.
And that it's a sole impact on a single lot of the 3 that are being proposed.
Correct. But that is not a condition of the approval, it is just a statement in the findings.
I understand, but then it goes into the record in terms of our deliberations and our
Yes. Yes.
resolution of this.
Anybody else have any comments from the planning board on this subdivision, not necessarily this matter? Anything else? I know, Lee J, you have recommendations when we get there. I had a few minor things compared to this. The plan, according to our ordinance, there should be a small location map showing where it's located in the town. The butters are still missing across the street, if you'd add those. And that one lonely little culvert, if we could show that on the plan.
Map reference. To town. And you said culvert?
Yeah, that one culvert, I guess you had a conversation with Public Works. Lot 3 doesn't need a culvert, but Lot 1 will require a culvert.
Okay, right where the driveway is. The driveway.
Yeah, I think he said something about 10 feet off the...
Right, yeah.
That would be a culvert that would go underneath the driveway.
Yes.
So that water is not deterred along the ditch line.
Hi.
Yeah,
Culvert on lot 1.
yeah, under the driveway.
Yep.
That's all I have. Anybody else have anything to add? Lee J, what, for the record, are you recommending?
Well, so I'm not gonna bore you with my whole memo. This project has certainly been reviewed and vetted. So I go to the recommendations that if the board does approve the application, that A, the plan approval is conditioned on oral and written statements made as part of the record of the application. B, that new homes built or placed on the property must have individual sprinkler systems installed in them. C, the driveway shown on the plan shall be constructed as shown. So in other words, where it's shown on this plan, where they are shown on the plan is where they need to be constructed. And conditions A, B, and C above shall be placed as statements on the final plan prior to its signing.
Driveway, construction.
We can get you a copy if you want of what he...
Yes. Under state law, all conditions of an approved plan have to be on the plan that gets recorded in the registry.
Understand.
All set? David, yes?
I would like to make a motion that we move to approve this plan, subject to the conditions that Vijay has noted, as well as the notation that our expectation, well, we can't use that as a condition, can we? We can do that in finding of fact, right, Vijay?
Right.
Okay, I would vote to approve the plan, incorporating the conditions Vijay has proposed.
And I would go on, I think, to add, just for clarity purposes, as conditions that Lori had, I think, 2, that a culvert be shown under the driveway on lot 1, and that a locus plan be added to the recording plan.
That's fine.
Well, this plan being the small little plan in the corner that shows
Right.
where in the town.
Down here, right?
Right.
Let that be added to my motion.
And the butters across the street.
Yeah, about us.
Minor, just minor.
Yeah.
May I have a second?
I'll second it.
Deborah has seconded. Angela, when you're ready, if you would do roll call vote, please.
David Christensen,
Yes.
Deborah,
Yes.
Edward Zelmano,
Yes.
Lori Anthony,
Yes.
Diane Gray.
Yes.
Motion passes.
So you need these changes and then we'll,
We need those changes, and then we will sign them.
right, so we'll come back to another meeting at that
For the
time.
next meeting.
Next meeting.
You don't need to hang around or anything. If you want to just drop that plan off with Angela, she would make sure that the board signs it
Okay.
at the next meeting.
And then we can
Or
record it.
in
Then we
prior
can,
to the next meeting and sign that.
all right, we can record it for you and get it back to you guys, right?
So we don't have to have another meeting. They can
No,
record it?
You guys are done.
Okay.
Except for findings of fact.
Yeah.
Thank you.
Thank you.
John, these are the final.
All right. I don't.
Down here on tour.
Yeah, let's go outside and look. Thank you, guys.
Okay. We have new business tonight. I'm going to assume this gentleman is setting up for the Sokokis Trail Borough-only facility.
Andy Morrell. Andy Morrell, BH2M.
Yes, Andy Morrell from BH2M. How you guys doing?
Fine, how are you?
Great, thank you. So Jalen Archer and Jim Wersakas, the applicants are here this evening. I got it.
We're missing the party out there.
Are you waiting on me to?
Nope, I was thinking that if Andy would like to do a brief presentation overall of the project, that would be first, if that's okay with you.
All right, I wasn't sure what was happening.
We're closing the door, that's all.
Okay.
Go ahead, Andy.
All right,
Thank
great.
you.
So I'm just going to introduce the project real quickly. If you guys have a question, just jump in. So 746 Sokokis Trail, 35-acre parcel, zoned AR. The existing parcel does have an existing house located approximately here, and an existing garage that's located over here. The applicant's looking to convert this house into a cultivation of medical marijuana where there will be no retail sales. I just want to go over some of the major aspects of the project for you guys. This existing garage, which is 40 by 60, will be converted for use at the facility, strictly on the first floor, as shown on sheet 1 of the plan. They're also proposing the construction of a 40 by 96 foot new building back here. That will be used for the facility. Proposing a 9-lot parking lot located over on this side. Per the ordinance, the ordinance requires 7 parking spots. We proposed 9 with 1 ADA space. That's based on the number of employees anticipated at the site. The existing driveway is going to be used for access to the site. We're not proposing an additional curb cut. That driveway doesn't meet access requirements, so we're proposing to widen it on the southern end of the driveway to meet the fire requirements for access, to make that 20 feet wide. We've also provided a turnaround located here for the fire trucks to be able to turn around, or delivery vehicles to be able to turn around on the site. We have provided turning schematics showing that I understand that the town's largest fire truck is 41 feet, so we've provided those turning motions for you guys. The proposed garage will be served by a septic system located down here. We provided the HHE 200 from Markhampton Associates. There's an
The
existing...
garage or the large building?
The proposed building
Okay.
out here, yeah, will be served by this septic system down here, yes. There's an existing drilled well located behind the existing house. That'll be used to serve the proposed garage building. And underground utilities will be run from the existing house over to the new proposed building. And then just a few other items I just want to point out for the board so that you guys are aware of them as we jump into this project. The applicant intends to either rent the existing house or to use it to house an on-site security personnel, depending on the needs of the site. We have proposed 2 wall-mounted lights on the exterior of the proposed building, located approximately here and here. We have provided photometrics for you guys on sheet 1 of the plans, and specifications for the lights are on, I believe, sheet 4 of the plans. Screening, I know that's something the board's going to want to talk about tonight. There's a relatively decent wooded buffer down along Sokokis Trail. There's also a pretty thick wooded buffer in this location here in the middle of the site. As part of our application, we provided some pictures from Sokokis Trail, kind of looking into the site, that I think will give you guys some perspective on that. Snow storage, we've handled with a note on the plans. We're going to store snow on this side of the parking lot and then up on this end of the parking up here. That's note number 21 on sheet 1 of the plans. Stormwater will be collected mostly in a closed drainage system, a catch basin located here, and an outlet over here on the eastern side of the existing garage. There's also a ditch that runs on the uphill side of the parcel that collects any runoff that flows towards the proposed building and directs it over to a level spreader down in this location here. I did receive Lee Jake's memo. It was very thorough, and we appreciate that. I just want to point out a couple of things in it. He did mention the conversion of the existing garage would need to meet NFPA requirements. The applicant does intend to meet those requirements. There was also a recommendation to expand the parking to meet the 200 square foot size. I did expand the parking lots and apparently didn't expand them large enough, so we'll certainly plan to expand these parking stalls 2 more feet to the north to meet that requirement. So the next time we come before you, you'll see those parking stalls were modified. With that, I know Jalen Archer is here this evening, and if you guys have questions about the facility or odor or security, I know he could hit on those items. So with that, I'll throw it back to the board or Lee J, and you guys can go where you want to go with it. So thank you.
Thank you. Lee J, do you want to go, or do you want the members to speak first?
Certainly, I'll go through my memo.
Okay.
I'm not going to read it verbatim, but I will try to get all the highlights for you. This is a medical marijuana grow only facility as proposed. The definition of such is in the zoning ordinance. It says a facility that engages only in the growing and processing of medical marijuana in accordance with state law but does not dispense marijuana. Processing of medical marijuana may include, but is not limited to, the preparation of tinctures, ointments, and food products containing medical marijuana. Medical marijuana grow-only facilities shall require a conditional use application as set forth in Article 2 and must be located on Route 5 or 202 in the agricultural resource residential zone. That was approved as a definition by the Select Board back in 2011 and has been on the books since then. There are no other standards relevant to this ordinance. However, and I'm not going to, I will say that the applicant has worked very closely previously with Glenn Chirac, when Glenn was with us, and myself. They met with us several times to discuss this and some of the issues that we had in designing it. Since that time, their plan came together. They have met, as the ordinance requires, within 5 days of submission of the plan. They met with the code officer, Mike, who is present this evening, myself, fire inspector, and Angela, and and we went through the plan, and we asked them questions, and we told them what our concerns were, and the plan you have in front of you tonight, for the most part, reflects that. Ian did mention the parking still needs to be adjusted a little bit. That could have been a CAD problem, whoever did your CAD work for you. Far as I got, no, I'm only kidding. So,
Okay.
I mean,
Yeah, treading on.
by the applicant to address these issues. The submission also does include odor control measures. I will say that I have worked on a number of these in other communities. Odor is the biggest issue, and what we've seen work in other communities is the charcoal filter systems, and when I directed the applicant to that, they looked at the other systems that were being done in the other communities that I've worked with, and went with that type of system as part of their proposal. So, we hope it works the way it's supposed to, and if it doesn't, then it would become a code matter for Mike to work with them to take care of that. Fire department also shared their comments. Again, one of the things that fire department had concerns with was the turnaround, and they've addressed that accordingly, and they provided the fire department with a template showing how the fire truck could back into the turnaround area and maneuver without any problems on site. An earlier version of the application did have a gated entrance, but it was discussed and felt that the gate would be too inhibiting for emergency vehicles to come in, because the need for Knox boxes and other things to address that, so that has been done away with. This evening, the board's task, although I've given you an approval recommendation, tonight's task by this board is to find the application complete and set the date for a public hearing and potential site walk if you feel you need one if you're not familiar with the property. I might suggest a site walk in this case so that you have a better understanding of the scale and locations of the site in relation to the abutting properties. So that's your task for tonight. I think the application and the submission has done a very good job with submitting everything required by the submission requirements. So I would have no problem if the application was found complete, and then you move forward with a public hearing date as well as the sidewalk.
Does any member of the board have any comments or questions? David, you're first.
Yes, thank you. I have two questions. First of all, with respect to odor control, I understand charcoal filters and so forth will mitigate that. What are the standards for odor control? How do you know if you've got it or don't?
You can smell it, trust me.
Personally, I don't know that. But I haven't lived downwind of a growing facility, and some people are more sensitive to this than others. So my question is, if you want to have odor control standard, what's the standard? Is there parts per million? Is there some sort of, we gather 25 random people and ask them if they can smell it? I don't know. So that's question number one. I'll go to my question number two also so that you can consider that, is that, and it goes back to sort of the security of the facility, and I don't know what the track record is on these kinds of operations in Maine with respect to prevention of some kind of a burglary or a robbery.
Rippers.
Or a jacking of a truck delivering product. How do you manage that, especially when it appears on this topographical map and the sidewalk will help that, to be more isolated? So
I'll answer part of that. I'll answer part of that question, but I think it's incumbent upon the applicant to provide you, I think they can provide you the information on their security systems and whatnot. First off, from our standpoint, the state regulates these things very high. They license them, and there is a state agency that regulates them. That state agency, the inspectors, are primarily former state police officers and other state police type of folks. They take this stuff very seriously. I've been involved in some other issues like this in another community. But they're also regulated from the standpoint of what comes into that facility and what goes out of that facility, by weight, by measures, by other things, and I'll let them talk about that as well. And they have discussed security matters with us as well. But I'll leave that for the applicant to kind of follow up on. Relevant to the odor issue, the town itself, I'm going to start by saying the town itself does not have any standards regarding odor control. And I don't know that the state actually has any standards. I have not come across any that says how many parts per million or anything like that. It's really I hate to say it, it's really a sense of smell and sensitivity, as you said, David, that some folks have a more sensitive nose to others. I mean, mine's horrible. I can't smell, food right in front of me. Where other people could probably smell this, 5 miles away. So that is always becomes a subjective issue as to how that's being handled. Andy or whoever's speaking on behalf of the applicant, do they want to talk about the security measures?
If I could just interrupt in terms of the odor issue, I mean, perhaps there would be room in this business plan to have a community, or some kind of a community advisory, community group.
A smeller group?
A sniffer group. Or that could be a source of contact for the applicant. If, maybe it's the planning board, I don't know. But someone, because again, at the end of the day, this is a controversial project. And it's going to generate concerns of people. To the extent that we can identify what those likely concerns are and have a solution or a mitigation in our minds before going forward, it's going to serve us all well. And since it's part of the community, then some part of the community ought to be, whether it's us or whether it's someone else, be a point of contact for receiving and presenting issues that are concerning. I'm thinking out loud.
Right. I mean, a couple of things. First, the point of contact is clearly your code enforcement officer. First, communication is to Mike, and Mike has to go out and check that out. What you're talking about, relevant to like a sniffer committee or something like that, really has to go through, and Dennis is on the call tonight, really has to go through the select board, I think, and seeing if they want to set up that type of a group and have a standing committee or a standing couple of people available to go and be judge and jury, if you will, if there are complaints beyond the code enforcement officer working with the applicant. That's nothing that this board has the authority to do.
We run the town center.
We rely on the code enforcement officer, and they just go out and they work with the applicant, and if they have to shut them down for a day or 2 or 3 until they can maybe put new charcoal systems in place or larger charcoal systems in place, then that's what they've done.
So the rule of thumb so far in Maine has been reliance on the code enforcement officer.
Mm-hmm. Yes.
That's fine, thank you.
Debbie, do you have any questions or comments at this point? Does anybody else on the planning board have any comments or questions at this point? No? Okay. I had a couple of things. If they rented the building out, will that be to a family or a business venture? And also, what are they going to use? I noticed that they're converting the first floor only in the garage. What is the second floor going to be utilized for?
I believe if the existing house is going to be rented, it'll be rented as a residential.
Yes.
So that would be, could be a family, could be a single person, it would be rented as a residential unit. And what are you doing with the second floor?
There is no second floor.
Okay.
Oh, okay,
Yeah.
so it was, I didn't think there was, but,
Yeah.
all right. Is there gonna be any signs?
No.
I didn't think so.
Now, the way that we've understood it, that
Jim, you probably, identify these guys.
I'm Jim Wersakas, the property
Just come
owner.
up to the podium and just identify yourself for the record.
Yeah,
Jim Wersakas, 342 Weber Road,
okay.
but I am the owner at 746 Sokokis Trail. The people that are going to do the marijuana facility is a good friend of mine, his brother, who's also going to be my son-in-law in 10 days. And my future son-in-law and daughter are the ones that will eventually take over that house. We talked about possibly security, that type of thing, but we're not going in that. They're going to be there, and they'll be owners of the facility as well. I just happen at this time to own the property.
All right. And there is a loading area in that building
What do you call that loading area?
for product in and out, supplies in and out?
Yeah, it'll just be through the doorway.
Just the regular
Yeah,
two
the
doors?
garage, we may keep one garage door on the existing building, but that may go away. And just be a regular, 3-foot door.
And then the only other comment I have now is the fire engine turnaround can't be blocked by a car. And in looking in the turning radius, in one movement, which would probably be used more than the others, shows that vehicle movement going into parking space number 9.
I can correct that.
If you could correct that and make it very apparent, no parking is there, if that's paved, if you could have the chevron go that way.
Sure.
And a signature block.
Sure.
Those are only my comments at the time for right now. Thank you for speaking. So so Lee, now we have to set up the public hearing and a possible site walk. When could you possibly have the corrections to the plans done? We could do the site walk and the public hearing before the plans are completed, right?
Sure. I mean, my assumption is they're fairly close at this point, with some very minor adjustments to the
Yeah,
plans
very
that are
minor.
needed. So, yeah, I mean, the site walk is going to get you an understanding, a better understanding of the property and the scale of the project.
My first,
Our preference, sorry to interrupt, our preference would be to do revisions after the sidewalk, in case there's anything that comes up at the sidewalk, we
Right.
can make those
Okay.
changes
Make
all
sure.
all at the same time, if that's agreeable to the board.
David, what do you got?
I think we ought to take a motion, which I will make, to recommend approval of the application with conditions recommended by Lee Jennings. If we go forward with that, then we'll schedule the sidewalk and the next step. And I think the first step was to, and again, I move that we recommend the application with 3 conditions recommended by Lee Jennings.
Just for clarification, David, you're talking about approval of the project, or you're talking about
Approval of the application
as complete, or,
as complete with the following conditions.
okay,
Item number 3 in your memo of May 21, page 4.
okay.
So, I mean, if we get that done, with the applicant expanding the parking area on the final plan, landscape materials, and Knox box issue, then we have that settled, and we can now have a platform to move forward to public hearing and cycle.
Okay, that clarifies it a little bit. You're not seeking approval of the project tonight, you just want them to add those conditions to their design
Yeah,
prior to. Okay.
and approval of the application is complete with
Complete.
those.
Yeah, okay. I just wanted to make sure that was clear.
So
Okay.
you want to,
My motion is that we approve the application as complete with the three conditions suggested
And we
by
say
the
approve.
EJ and the memo made
Just say
21
fine.
on page 411.
I would just take the word approve out of there and just say that the board finds the application complete.
That's fine.
You don't even need the word
I
approve.
have no problem with that. So the motion would be that we find that the planning board finds the application complete with the conditions noted by the judge.
To be added to the plans.
Yes.
my feeling is to have the site walk and the public hearing and then do that.
I really disagree on that.
Yeah, I think the application is complete, it's just not finalized yet.
The sidewalk and the public hearing are going to help us get to the point of an approval. All we're doing is saying is that the application work has been completed.
Well, it's not.
And
Have
if we get
changes.
to the sidewalk, the public hearing, and there's some issues that arise that we want to address, we can address them.
Yeah, I mean, so let's just all get on the same playing field here, that the conditions that I added were the conditions that I saw as remaining issues. If they add that, that's certainly fine, but understand, all board members, that you may still have additional conditions that are gonna come out of the public hearing or your sidewalk.
That's what I'm
So don't think that, the plan will be fait accompli just because they addressed those three things that I had in my memo. There still may be other things that you may need, that you may want to do or see once you've heard the public and walked the site.
And that would be my preference. My preference, and I'll just put this out there, is to do the public hearing and the site work before we deem anything complete or approved, including the application.
We have a motion on the floor.
Okay,
Second.
I'll second it.
it has been seconded. Angela, if you would do roll call vote when you get a chance.
David Christensen,
Yes.
Deborah Burrows,
Yes.
Edward Zelmanow,
Yes.
Lori Anthony,
No?
Diane Gray.
Yes.
Motion passes.
That said, you want to schedule, is the board looking for a site walk and a public hearing?
Yes.
Both. Both, David?
Well, we have to do the public hearing.
Yeah, we have to do the public hearing, but sidewalk, we need
Yeah,
to.
Just
sidewalk
like-
as well.
Okay, thank you.
And if I can, I would ask the applicant to mark the full width, stake out the full width of the roadway and the four corners of the building to be built,
Okay.
be put in.
Anything else the board would like to see specifically shown on the ground before you guys come out there? Four corners of the building and the edges of the access road is what I'm hearing, and the parking?
Why is the septic system so close down?
That's pretty much covers everything to the right.
Yeah.
Okay.
On the site. Yeah.
If for any reason this didn't go, not approval from you, a year, 2 years, 5 years, they don't want to do this anymore. That septic system could be used for housing. You could put a house in front of there and still have the garage. So it's just looking at the future. There's no sense to put it right in the front.
No, it's fine, it just seemed like light years away.
It was specifically put there, to be as far out of the way.
And are you planning on doing the site walk on the before the planning board meeting on the 16th?
I think we should.
Suggestions?
I think we should, so we have more, so we can speak of us being there. So we can answer specific questions.
There have been times that we've done the sidewalk just prior to the meeting.
Correct.
Maybe 5:30 or something like that, or.
I won't be there.
And maybe 7 o'clock.
How many people will be able to show up early on the 16th for a site walk?
Yes. Do you think we should do a sidewalk before, a day or, a little bit before the meeting? So in case, I don't know if I'm going to be able to wrap my head around it if I'm going there at 5:30 and then we're at the public hearing. I mean, it's a lot to look at.
Feelings?
We've done it before without a problem, and the solar farms, we've done that with, and that worked pretty smoothly.
Could I ask, were you planning to have a public hearing on the 16th as well?
That was, yeah, great, yeah. So are we doing sidewalk, public hearing, and review all in one night? Is that what you're proposing, David?
Yeah.
I
It
disagree.
sounds to me like the board is saying, hold off on changes until after the sidewalk.
That's fine, yeah.
Right.
Yeah, it's going to be hard to do everything in one day because
you're-
any changes found
Any
that come out of the
changes.
sidewalk.
We can certainly provide revisions prior to the 16th to the board if you guys would.
Well, if there are changes that you have, that would become a condition of the approval.
Okay.
And we can condition them on not obtaining any building permits until after the plans have been revised accordingly.
Okay.
So, yeah, I mean, you can condition, and I can work with you as we've done in the past on any conditions kind of on the fly the night of the meeting if you need it.
Okay.
With that being said, feelings from the board. David wants to do everything in one night. I would prefer to do a site walk prior to. Any other members want to speak?
I agree with Lori that we need to do a sidewalk prior to.
I have two other members here. Any preference?
I just won't be able to be at the site walk, that's all, so.
If it's another night, could you be?
Yeah, if it wasn't early, I mean, it's hard enough just to get here for this meeting.
The option for you, Ed, is if the applicant will give you approval, you can go by yourself without other board members and go to the site and walk around to get a feel for it if you feel comfortable doing that. And if they will allow you to access the site.
Oh, I didn't know you needed the people's permission.
Okay, I don't see any major issues with the site as it is, so I don't know if I even would need a site walk.
And that's certainly your prerogative as a board member.
Can everybody else show up at 5:30 on the 16th? Looks like we will be having the sidewalk on the 16th at 5:30. You can be there?
Yes.
Are we doing the public hearing for 6:30?
That's what you
Yes, I hope so.
that's what you
Yeah,
found
just
in
during the
file.
meeting.
Okay. I'm just verifying with my members. Okay? And then we will do regular business afterwards.
Yes.
Would the board prefer us to submit revised plans with the things we've talked about prior to that planning board meeting? Or would you rather us hold off on changes?
Number one, you have one day to do all those changes. So I would say that we weren't looking for all the changes on the 16th, were we? Because there could
What
possibly be
changes?
more.
What changes do you need?
Lee J said we just make provisions of them.
Doesn't sound like it's any of the changes are major,
No.
and it could just be held off this way. You're not revising and revising.
Great,
Save the applicant some money.
great. Thank you. So no changes until the sidewalk.
Mike, did your stuff get addressed already?
Yeah, it was in the Jay's memo. It was a 245.
So I'd like to make a motion that we table the application to the 16th.
Okay, can I have a second?
No. I think we have a motion on the floor.
Oh, we have to approve, David's got his motion.
Oh, you still got your motion?
Yeah, we
You
have
already passed. You guys
Yeah.
are.
Yeah, we already
voted.
passed that.
You're muted, David.
Why do we need to table anything if we've already done the application? Now we're just simply scheduling the next step. I don't know if it's table or not.
No, you don't have to.
Yeah, I didn't think we did.
You don't want to.
It's been voted on and passed,
Nothing's been passed.
nothing tabled. You voted to accept the application.
We have a pending application.
You found the application complete and you set the date for the sidewalk and public hearing.
Right,
That pretty much concludes that action on this project for now.
yeah. Thank you.
Thank you.
Thank you.
Good to see
We will
Andy.
see you the
Saves
16th.
me.
Andy, the letter
Yes.
that you sent in the draft, and you and I looked it over in public notice.
Yeah.
So it's gonna go out tomorrow. You
Sure.
can fill in the dates for the sidewalk and the public hearing
Yep.
in your gaps and ship them out tomorrow.
I will do that. Listen to a regular now, right? We'll not have to-
Certified.
Certified.
Got it. Will do. Thank you.
You're welcome.
Okay, new business, public hearings are done. Old business, we already have addressed and found that one final. Next thing on the agenda is communication. No communications. DJ, you have anything?
I have nothing. I don't know if Dennis has anything or not. I don't have anything.
Okay. Dennis, do you have anything on the communication or miscellaneous? You're muted, Dennis.
You're muted, Dennis. You're muted.
We voted last night to not to pass the, or to delay passing the solar ordinance. Because I think we need to get together with a workshop. There's still some questions over the different zones that it's allowed in and whatnot, and there were some other issues that came up. So we will get in touch with everybody. We'll invite the planning board members to that meeting as well. And then we'll have after that, we'll have another public hearing. So we did not execute last night.
Thank you, Dennis. Did you have anything?
Just one other thing. DJ, do we know if the governor's emergency order expires on the 13th or 14th of June? Because
Don't know. I have not heard
that impacts whether or not we can continue to have Zoom meetings.
Correct. So here, I don't know the date. I don't know if she's gonna plan on extending it or not. If she does not extend it, we have 30 days to go back to doing things the old way. So there's like a time.
So there's a window.
There's a window. There is a piece of legislation that has been in the workshop. Natalie Burns, your attorney and my attorney at SMPDC, has been tracking it, that would allow municipalities to continue to Zoom their meetings if they chose to do that. We have heard in York County region from a number of folks that actually would prefer to do that. They feel as though they've had more public involvement because people don't have to leave their house. And board members have felt comfortable from other communities and continuing to operate like this. So there is a piece of legislation and it's in a workshop right now. I don't know what the outcome is going to be, but Jensen, Baird, Gardner, and Henry, as I'm sure many of the municipal law firms are tracking that, so we will know from our attorney at some point whether that's a go or no go.
Thank you. Anything else, Dennis?
What's that?
Okay, thank you. Motion to adjourn?
Motion to adjourn.
Second?
Second.
Angela, when you're ready?
Just say, oh.
David Christensen,
Adjourned.
Deborah. Please. Edward Delmano,
Yes, please.
Lori Anthony,
Yes.
Diane Gray.
Yes.
This meeting is adjourned, and there's nothing that needs to be signed, so we're all set. Good night, everyone.